Jacob Chansley, the QAnon shaman, just got a new lawyer. If you remember his prior lawyer, a guy by the name of Albert Watkins, it's a little bit crazy talking about crack sometimes being okay. And Jacob Chansley got a very, very long prison sentence that surprised a lot of people, given that what he did was essentially wear a costume and do the same thing that a lot of other people did, and he got a lot more serious long-term prison sentence than many of the others. Who is this new lawyer? Let's take a look at the federal docket. You can see Albert Watkins down here, terminated 11/29/2021. He's no longer with us, and replaced by John M. Pierce Bainbridge. This is the same John Pierce that Kyle Rittenhouse said was somebody who recommended that he continue to stay in jail, said it was safer for him to stay in jail. And we've had a lot of criticisms of John Pierce on this channel for some time. Here, he is back now on Jacob Chansley's case. Jacob Chansley, of course, has been sort of put through the ringer. We see that the disposition on this is the defendant is sentenced to the custody of Bureau of Prisons for a term of 41 months. He's going to get credit for time served, and the defendant is going to be further sentenced to a 36-month term of supervised release. After he is done, a defendant further ordered to pay a $100 special assessment. So disposition resulted in a lot of the dismissal of other charges, but certainly he is going to be in custody for a very long time. And so one of the things that happens in a criminal case is you can resolve it a number of different ways. One of the best ways to resolve a criminal case from a defense perspective, which is what I am, is to have the case dismissed if I'm representing somebody. I say, Judge, Mr. Prosecutor, this case is not justified. There's no basis for bringing these criminal charges. We ask for a dismissal. The prosecution voluntarily dismisses the charges, or we fight about it and the judge dismisses the charges for a whole slew of different reasons. That's one way to dispose of a case. Another way to dispose of a case is to take the case to trial. You can't reach a voluntary type of a dismissal, and so you can't reach any other agreement. So what you have to do on the other end is just go to trial, which we have seen and covered many times on this channel. We've talked a lot about Derek Chauvin and Kyle Rittenhouse. There were no plea deals. There were no dismissals. The only thing that they had to do was go to trial. Some of them won, some of them lost. That's a disposition in the case. Kyle Rittenhouse was acquitted of all charges, not guilty. Derek Chauvin went the other way. So those are other ways to dispose of a case. The third way is through a plea agreement. That's where the defense and the prosecution, they come to an agreement. They say, listen, we know what the original charges are, and we think that maybe we're going to accept responsibility for some of these things as long as you give us a benefit, as long as there's some sort of justification, some rationale. We're going to get a decent deal out of this that justifies us pleading guilty. If you're going to dismiss some of the charges, well, then maybe we will go ahead and plead guilty. Because if we go to trial and lose, we might have more exposure. And at the conclusion of a trial, we might be found guilty on all of the charges. And that would really increase our exposure. And so now what we want to do is limit any of that potential volatility. So we'll just keep it confined to a plea deal and we'll negotiate it. That's what happened in the Jacob Chansley case. There was a plea deal, and this is what they negotiated. There was no trial in this case. So the original complaint had a number of different charges, but you see all of these were dismissed. So Jacob Chansley got a benefit out of this plea deal. He was sentenced to custody, and he entered this agreement. When you go back down and you take a look at the case in its entirety, you can see that the original sealed complaint has some other documents in it. And let's poke around and see what those are. Here, violent entry, disorderly conduct, several different counts there. We talked about those previously, but we scroll all the way down to the court docket and we're going to see that Jacob Chansley now has a new lawyer. And so some new recent activity starting on about 11/24. We've got motion to leave to file under seal. Here it is. We've got a notice of appearance. So back on 11/22, we get a notice of appearance from John M. Pierce, out of Pierce Bainbridge. Says, I'm admitted, otherwise authorized to practice. I appear as counsel. So he entered his appearance there. Then we can go back out and see what comes up after that. So files motion for leave, order granting motion for leave. We set a status conference. So we had that on 11/29. There's an order setting that. Looks like John Pierce is going to be calling in via Zoom for that status conference. Counsel for the defendant asks to be appearing for Zoom. He says, I live in LA. Would like to be able to call into the motion hearing and be on standby should the court have any questions, with another California licensed attorney being present. So John Pierce wants to call in because he's on the other side of the country. And so the judge presumably changes the courtroom, allows John Pierce to appear by telephone. Courtroom change, they call in, and so we get a minute entry now. The minute entry for the proceeding, status conference as to Jacob Chansley. Oral motion by Albert Watkins to withdraw as counsel. So Albert, the prior crackhead lawyer, is now off the case. And then we have, that's granted. Judge says, you're free to go. Bond status remains committed. He's still going to be in custody. Defense attorneys, and then we've got John Pierce, Shipley's there as well. Then we have an order as to Jacob Chansley regarding a motion to leave to appear pro hoc vice. Let's see what the judge is talking about in this order. Before the court is the defendant's motion to admit William Shipley pro hoc vice. Local rules instructs any attorney seeking to appear to file a motion setting forth, among other things, a list of all bars to which the attorney has been admitted. The court has reason to believe that Mr. Shipley was admitted to California in 1988. Court orders defendants to supplement his motion with a list of all bars to which Mr. Shipley has been admitted, and the court further orders the defendant to supplement his motion with an explanation as to why Mr. Shipley is not eligible to practice law in California. Interesting. So there's something going on about Mr. Shipley. Not sure what that is. And then we get here the notice of appeal. This is by Mr. John Pierce. Very basic, as we can see. This is just a notice to appeal. Just the notice. This is not the actual appeal. So there are sort of two things that happen, broad strokes, when you're filing an appeal. One, you got to notify the court that you're going to be appealing this. You don't just get to walk in with a huge appellate memorandum, a big, 100-page brief, and say, appealed, take it. You say, we're going to file a notice of appeal, and then we're going to do our investigation. We're going to request transcripts, and we're going to, go through everything and find any appealable issues that are worth investigating. In this case, I'm not sure what John Pierce is going to be doing, but he's going to look through everything and justify, I'm sure, a big fat expense for drafting an appeal. But he has to notify them first before that timeline expires. So it's going to be a short timeline. You file the notice. Once the court knows that you're going to be appealing, they're going to give you a lot more time to actually go and prepare the appeal. In this case, John Pierce may be attempting to see what else happened with some of these competency hearings. Remember, with Jacob Chansley, there was a question about his competency. And if we scroll back earlier on in the minute entries, in fact, I think that we're even going to be able to sort of see that they were. So we got some motions to compel competent. Yeah, so we have a competency proceeding that took place back on 9/3. Minute entry for the video plea agreement is held before the judge. Court makes a finding that the defendant is competent to stand trial for reasons stated on the record. So what are the bases for John Pierce to appeal this? I explained the three different types of a case or types of disposition, the broad buckets. A dismissal, there's nothing to appeal for a defendant because your case is gone. Case has been dismissed, so why would you appeal that? If you lose at a trial, well, you can appeal that because you lost. And as long as you've got an appealable issue, you can appeal that. And if you win at trial, well, you won, so there's nothing to appeal there. But if you enter into a plea deal, if you enter into a plea agreement, what are you appealing? Because you entered into that agreement. So typically you don't have much to appeal there unless you're just going to be appealing sort of the sentence. But the sentence, in this case, was within the boundaries of the plea deal, which was actually less than what the prosecution was asking for. I think they were asking for 4 years, and he got a little bit less than that. So it was within the confines of the known plea So what are they appealing? Well, maybe it had to do with his competency. Maybe he actually didn't know what he was signing. Maybe his attorney was so wacky that Jacob Chansley was so poorly represented that he didn't understand what the heck was going on. So then you go back and you take a look at this proceeding, what happened on 9/3 when they actually entered that plea deal. Court makes a finding that the defendant is in fact competent to stand trial. He's sworn, he enters a plea of guilty. Court accepts the plea. He's found guilty. Pre-sentence investigation report is ordered. Sentence memorandum is due. Sentencing set for 11/17. So then we fast forward from 11/17. We go over there. Then we get sentencing. Judgment of this court, defendant is sentenced to in custody term of 41 months. Credit for time served. 36 months supervised release. Everything else is granted. Everybody's there. He remains committed. He knew what the terms of the plea deal were. He got time for that. And so prosecution presumably was asking for more time, and he got less than that. Let's see, the statement of the reasons of the judgment. Don't think we've ever covered that here. Pleaded to guilty, count 2 of the indictment. Remanded to custody, placement. Oh, he's coming back to Phoenix at FCI Phoenix to be near family members. 36 years of supervised release upon discharge. $2,000 restitution. Let's take a look at the statement of the reasons. Oh, not going to give us that. Notice of appearance, and then that's when John Pierce entered his case. So we'll see what John Pierce is going to do with this case. It's a plea deal. He entered into it. He agreed to it. John Pierce is filing a notice of appeal. So at some point, we'll see what the actual appellate memorandum looks like, I'm sure, and we'll see what his arguments are there. But if you're Jacob Chansley's family or anybody rooting for Jacob Chansley, I wouldn't get your hopes up. He entered into a plea deal. The court found him to be competent, and it sounds like he is, within the confines of the plea deal. So unless there's some basis for John Pierce to latch onto, honestly, I'm afraid that he's just going to milk this appeal for donation money or whatever until the end of time. Endless appeals, very, very profitable. And we've seen sort of the roadmap for this fella for a long time. So we're going to continue to follow along Jacob Chansley's case and many others. I hope you join us in that journey. Stick around, hit that subscribe button, give us a like before you leave, share the video with a friend or family member, and I will see you on the next one.